and we are going to figure out how those are actually divided. We're going to go through sort of what the court looks at when we're dividing assets, especially in a marriage. We're going to not talk too much about the custody aspect today because we do things slightly differently. We're not dividing assets when we're talking just about a custody case. So we're going to take a pause on that. We'll return to that next month. We're going to talk more about kiddos next month. But this month we'll talk about, we got all those financial disclosures together. We did all the hard work, and now what does that mean? What is the next step? So we're going to talk about division of marital property, which I'm excited to dive into today, and hopefully you'll find it really helpful to understand a little bit more about one of the more complex areas of the divorce process. So as you have maybe figured out, or is maybe a reason that you're here today, getting information you can trust about the legal system can be really challenging. The system itself is complex. You're not sure if you find something online, if it's accurate, if it's up to date, if it's what you should do. Sometimes you get more information than you need. And that's really why I started this Family Law Hour webinar series, was to provide that basic information from a trusted source, right? I'm an attorney. I do this day in and day out. I only work on family law cases. And I really just don't believe that folks should have to drain their savings or their retirement or go into massive debt just to break up. And sometimes we can really save on some of that cost by just getting the basic information that we need to know what our next steps are. So I have certainly seen folks pay $10,000, $20,000 or more to get divorced. Sometimes they're not even at the finish line yet, which really breaks my heart when I see that. But if you can be amicable, if you're cooperating with your spouse, if you're just taking a rational, realistic approach, you should be rewarded for that, right? You shouldn't have to pay extra because you're working with an attorney or you're getting some legal help. So I hope that you'll find that my approach is pretty down to earth. I try and make everything really accessible and easy to understand because I'm committed to simplifying the legal process and just making it suck a little bit less. That being said, every case is different. Every case deserves individual attention. So today I'm going to provide information in general about the process in Colorado, specifically about dividing a marital estate. This is only in Colorado. Every state handles things differently, but nothing that I say today should be taken as legal advice. I don't know the specifics about you or your situation, and so the information I'm providing, you may have questions after that about how that applies specifically to you, and in that case, you really do want to talk to an attorney so that they can give you that one-on-one individual advice so that you know that you're applying the information correctly in your case. So that being said, let's jump in and talk about the division of the marital estate. So when we talk about a divorce, the court is going to call it a dissolution of marriage. Everyday folks, we call it a divorce. It's the same exact thing. You can be married in Colorado both by a sort of a formal ceremony or getting a license, and you can also be married by common law. We're one of the few states still that recognize common law. Again, if you think that that might be something that applies to you, that you were married by common law, you do want to talk to an attorney to make sure that that is the case. But if you have a marriage that was solemnized in whatever way it was, the date of the marriage is going to be really important because, as we talked about last month, that's going to be the line in the sand where we're starting to look at what is the marital estate, because that's what we're going to divide as part of the divorce. So the financial disclosures are required in every divorce case. And if you were wondering last time or wondering while you're in it, why do I have to disclose all these documents? Why do I have to provide 3 years of tax returns and all my bank statements and all of this information? The reason is we have to have all of the correct and accurate information on the table so that when we go into this next step of dividing everything, we know what we're talking about. If you don't provide that information, if your spouse doesn't provide that information, we really can't fairly divide things because we don't know what we're looking at. So we look at the financial information both for the division of the marital estate and then also for support potentially. So there's spousal support, and then if you have children within the marriage, child support. We're not going to get too much into the support aspect of it today. We're going to save that for another month because that's a whole nother can of worms. But we are going to talk about the marital estate. So if you're wondering what's included in that, take a look back at that sworn financial statement that you completed, your spouse's sworn financial statement, any supporting schedule if you had a retirement account or an investment account or miscellaneous assets that were listed on there. That all goes together. And then all of the supporting documents, so the tax returns, the bank statements, the pay stubs, the statements of car loans and mortgage loans, all that stuff. Make sure that you have all of that ready to go, because that's going to be your starting point to figure out what is in the marital estate. So before we talk about the marital estate, we've got to talk about separate property, because that helps us define what the marital estate is. So separate property in Colorado is going to be something that you owned or had in your possession before the date of the marriage. So that date of the marriage, as I mentioned earlier, is really that line in the sand, and that's what Colorado courts are going to look at to define marital property in general. So if you owned a car before you got married, most likely that car is going to be considered your separate property. If you owned a piece of furniture, if you owned a pet, if you owned a house, it is likely going to be considered separate property, but there are some caveats to that. And I smiled when I said house, because those are the type of assets, those ones that appreciate. Houses, 401ks, retirement plans, those are kind of the most common. The appreciation that happens during the marriage is actually part of the marital estate. So you have to be really careful as you go through each individual asset and debt, and to understand, when was this acquired by either party, and has it appreciated or even depreciated during the marriage. And if you'll notice, I'm not talking about how things are titled. So sometimes folks will buy a car, let's say during the marriage, and they'll only put it in the wife's name. So they think, well, that's got to be the wife's because it's only in her name. That's not quite the case here in Colorado. Again, what they're going to look at is, when was it acquired? When was it purchased? When did it come into the marriage by either spouse? And regardless of whose name is on it. So it can be on one spouse's name, it can be on both spouses' names, but it was during the marriage. So that car in that example will be considered marital property. So you'll want to go through all of the items on the sworn financial statement, all of the documents that you received, and make a list of everything both that you and your spouse have that's going to make up this bucket that is the marital estate. And that's includes marital property and debt. So the estate is kind of both of them in conjunction. So anything acquired after the marriage, whether it's an asset or a debt, regardless of whose name is on it, it just depends on that date, is going to be in that bucket of marital property or the marital estate that we're going to divide as part of a divorce. Separate property that appreciated, the amount of appreciation is also going to be in that bucket. That can get tricky, and this is where, again, you'll want to get specific legal advice on your situation, because a lot of times when folks get married, they don't think, oh, let me double check what my house is worth because I might need it down the road. They just get married and they don't think about it. And if years have gone by, it can sometimes be really hard to establish what the asset was worth at the time of marriage to then know how much it's appreciated. So those can be tricky, and those are definitely situations, if you find yourself that applies to you, you're going to want to seek legal advice on exactly what to do so that you can make sure it's fair, right? That's really what all of this comes down to. Also, any income received during the marriage. So typically that gets divided up into bank accounts and it's used to pay bills, but any of that money that funnels through a bank account, even if the account is only in one party's name, is technically going to be a marital asset because it was received during the marriage. So think of all of those things, make a list, and that's going to be your starting point. So after those financial disclosures are done, that's when you can do this, right? You can't do it before you have all of that information. And I find it really helpful to create a spreadsheet of everything. I put all of the assets on the top part, all of the debts, and then start filling in the values. So if it's something like a car that has a value in and of itself, but then it also may have a loan associated with it, you'll put the value of the car, the loan, and then obviously you'll be left with equity, whether it's positive or potentially negative. Same with the house. For assets like bank accounts, retirement accounts, they're just usually going to have the value. They typically don't have a loan associated with them, although sometimes they can. But you'll just put the value of all of those. And again, you know the value is accurate because we got all of those documents together, right? So all of that hard work is ultimately going to pay off because it makes sure that things are done accurately and above the table. You'll go through and create, I find it most helpful to create a spreadsheet, but whatever works for you. You'll put everything down, both that you own, that your spouse owns, anything you guys own together. Once you do that, you start kind of going through and dividing things up, right? So you may say, this bank account I take entirely, and this bank account my spouse is going to take entirely. Maybe the house, you guys decide to sell it and split it. Maybe the split is 60-40, maybe it's 50-50, maybe it's 70-30. That's all entirely up to you. Ideally, the court would like to see the spouses reach an agreement, because at the end of the day, this is your money, these are your finances. You guys are going to know best on what is equitable or fair as a division in that property, or an allocation of those debts that may still be there. If you can't do it just on your own, but having some additional help would be helpful, so that you can maybe better communicate, maybe have a third party who can think outside the box a little bit and say, oh, have you guys thought about this? Maybe we could divide things that way. That's where mediation really comes into play and is really helpful. And in most divorce cases in Colorado, mediation is going to be required, generally for that reason, right? The court, again, wants the spouses to try and figure it out. And people generally find that it's helpful to have that neutral third party come in and just act as a facilitator and someone who can help the parties communicate and hopefully find a resolution. So if you can do that, fantastic. You do want to have all of your disclosures done before mediation, if that's the road that you're going to go down. Again, if you don't have all the numbers and the assets and debts in front of you, it's really hard to have a productive mediation because you don't know everything that you're talking about. So some things to consider if it applies in your situation as well is possibly talking to other professionals, maybe a tax expert, maybe an accountant, because sometimes when property is divided, depending on how it's divided between spouses, that can have different impacts down the road. And so you want to make sure that, it may sound really great to divide a particular asset in half, but in doing so, maybe you have a specific tax implication for that, or down the road, that's not going to grow as much as maybe as if you got an investment, took less of an investment account. So all of that's going to be in play. Again, you don't want to go through that aspect alone, just like you wouldn't want to go through the legal process necessarily alone. If you have any of those situations where having additional professionals look at your finances and look at how you're proposing maybe things be divided to let you know what the future implications could be, that's a really good thing to take advantage of, just so that you know you're setting yourself up in the future to have what you need financially. And if you're not, at least you're aware of that situation so you can plan accordingly. So take heed of that, do what you need to get all of the information you need to make the best decision for yourself. And then be able to propose a settlement agreement to your spouse. And hopefully the two of you can work together and say, this is how we're going to divide our assets and debts between us. If you can't reach a resolution, whether it's on every single item on that list or some of the items or maybe even just one, ultimately a decision is going to have to be made because that's part of the divorce process, right? One of the functions is to legally and financially separate the parties so that they don't have any ties together anymore. And you certainly don't want to have, if you can avoid it, any financial ties to your soon-to-be ex-spouse. So if there's something you can't agree upon, the court's going to make a decision for you. And the mechanism by which that happens is there's a hearing. So the court has everybody come in. One spouse says their side, I think the house should be divided this way. The other spouse says their side, I think it should be divided this way. They each give their reasons and rationale and support. And then the court takes a look at it and they decide to divide it in a way that is equitable. And so what that means is it's just fair. It's not necessarily equal, which is where sometimes folks make that assumption that it's no matter what going to be divided 50-50. Oftentimes that is what is most fair, but sometimes there are other situations or other factors in a marriage that the court considers and says, I think in this situation fair is actually 55-45 or 60-40 or whatever the case may be. And so the court will take into consideration a number of factors to figure out what is going to be equitable or fair for this particular couple who is divorcing for whatever the assets or debts they are in front of the court to make a decision on. So some of those factors, just so you're aware that the court's going to think about, is the contribution of each spouse to the acquisition of that marital property, including contributions as a homemaker. So contributions in a marriage aren't always just directly financial. There are often times when one spouse is a predominantly financial provider and the other spouse provides in non-economic ways, like being a homemaker. So the court is going to take that into consideration. It's not enough to just say, well, I paid for everything because I work, and so I should get all of the assets and my spouse should not get anything because they didn't contribute economically or financially. And those contributions, whether they're financial or not, the court's going to consider what each spouse made to the acquisition of the particular asset. The value of the property that's set apart to each spouse. So this is either separate property that maybe people have before the marriage that they're going to continue to retain, or if the spouses have come to some agreement already, the court's going to want to see what that looks like and what each spouse is getting and take that into consideration, again, to make sure that it's as fair as possible. They're also going to look at the economic circumstances of each spouse at the time of the division of property is to become effective. So usually that's around the time of the divorce. Sometimes it can be a few months or even up to a year or more later. So the court's going to kind of look at where is everybody going to be at that time. And they're also going to think about the desirability of awarding the family home or the right to live in it for reasonable periods of time to the spouse with whom any children may reside a majority of the time. So that basically says if what we're talking about is a house, that's the item that the spouses can't reach an agreement on, the court's also going to look at where is each spouse going to be at financially when this house is divided or the determination is that it needs to be sold, and who's got the kids the majority of the time, right? Because if that's the kids' home, the court is going to be cautious about just outright selling it, maybe. Not to say that that may not be the outcome, but they're certainly going to take it into consideration, right? They understand that none of this is happening in a vacuum, and that oftentimes if this was a family and this is a family that has children, the family is looking very different in the future, but it's still a family, and the court is going to want to take into consideration how other members of the family, like children, would be affected by its decisions. And then they're going to look at any increase or decrease in the value of separate property of the spouses during the marriage, or the depletion of separate property for marital purposes. So that just means if somebody comes into the marriage and they have $1 million of separate assets, and that's not being divided as part of the marriage because it's separate, the court wants to know that. Obviously, that spouse has some economic means. So it's not as if the spouse has nothing if they don't get something, some part of the marital property. And if that spouse possibly used half of their separate property to fund the marriage or buy the marital home or contribute economically to the parties because somebody got laid off, any of those factors or contributions the court can also consider. Because again, they're not looking at, we're just talking about the house, let's look at it in a vacuum. It's worth $500,000 and there's a $300,000 mortgage on it. So there's $200,000 we need to divide. They're trying to look at it in a bigger picture for this particular family's or couple's situation. So there's a number of factors that the court's going to consider if there's anything that the spouses can't agree on how to divide, whether that's both an asset or a debt. The court wants to do really that good analysis to make sure that it's dividing it equitably, right? Or fairly, that the way that it allocates it is fair to the parties. So last thing on how it's divided is Colorado is a no-fault state. So that means that you can get divorced, just say that there are irreconcilable differences, but you don't have to have a reason. And you also, if there was any marital misconduct or the spouse was just kind of a jerk and that's why you need to get divorced, or they had an affair, or they had a gambling addiction, whatever it is, Colorado is a no-fault state. So that means that in general, there are some exceptions. And again, this is one of those areas that if you're thinking maybe there's an exception in my case, or I'm hoping there's an exception in my case, you're going to want to talk to an attorney about it. But in general, the court doesn't consider marital misconduct when it divides assets. So that means you can't come into court and say, I want more of the house because he is just a jerk. Here's all the terrible things that he did. He should have to pay for those things. We don't do that in Colorado. We're a no-fault state. Again, there are some exceptions, especially if there are marital assets that are dissipated or wasted by one party. That could sometimes come back into play. But it's in general a no-fault state. So just keep that in mind. It can be really hard when you're in it to not feel like you deserve something more because of the behavior of the other party. Obviously, you're getting divorced for a reason. Things are not going well, and that could very well be because the other party had some serious misconduct. But in general, you will probably not be made whole by getting more of the marital estate because we're a no-fault state. So just keep that in mind. Just temper expectations a little bit that the court process is not going to be there to chastise the other party or punish them in some way for that behavior, especially in the division of marital property or debts. So just keep that in mind. And again, if you have any specifics, if you're like, man, that really isn't fair in my case, I should get something because of these reasons, talk to an attorney and they'll be able to let you know if your situation falls into kind of one of those exceptions where we can talk about it, but just know in general, we generally don't. Okay. Questions that I get sometimes is, okay, we've figured out how everything's going to be divided, but I'm getting the car that's in his name. How do we do that, right? So it's one thing to say, here's what each of us is getting. How do we logistically and practically make that happen? So if a title needs to be retitled, it needs to be transferred from one spouse to the other. It can be done after the divorce is finalized. Some spouses agree to do it beforehand. It really just depends on what you agree upon, but that is a function of the divorce, is to get that order in place and then transfer any of those titles that need to happen. Ideally, the reason that we want to transfer title and completely remove from bank accounts or loans the other person's name if they are not responsible is we don't want to have those financial ties once the divorce is finalized. The reason for that could be that, one, it makes things super confusing, and worst case scenario, there could be a spouse who's on a debt who's not responsible for that debt, but to the creditor, it doesn't matter, their name is still on there, and so they're going to bug that spouse about it. We want to just avoid that. We want to remove as much as we can the parties so that they're not jointly on anything once the divorce is finalized. Okay. That's a lot. Going through the marital estate can be really overwhelming. There may be, you may have a lot of questions. As I've mentioned before in a lot of these webinars, is the process is designed for you to do it yourself. I know that might sound funny because we've just went over one small piece and you may already be overwhelmed, but it is designed in Colorado to do it yourself. But what I generally find is somebody somewhere along the way has questions, right? It could be right now, you could have 10 questions. It could be a little ways down the road. Maybe this makes sense to you, but you've got questions when we start talking about kids or spousal support. And so because of that, you will want to have some resources, right? And so I want to cover some of the common questions that I get. So in case they're in your brain, you can get some information. And then we're going to talk about how can you do this for less than $500 to make it as inexpensive as possible, but hopefully still get to the finish line in a way that works for you and allows you to move on. So the question I get a lot is, can a spouse make a claim on my retirement? So can my spouse claim a portion of my retirement. If I'm the one who always contributed to it, they didn't contribute anything directly. The answer is generally most likely. Again, your specific situation, you want to talk to someone about it to confirm, but retirement accounts fall into that designation of assets that may have been acquired or in existence before the marriage. So you were working and you got your retirement account 5 years later, you got married, and then you were married for 5 years after that. In that scenario, if the retirement account appreciated during that 5-year marriage, the amount of appreciation, the other spouse likely has a claim to a portion of it because the appreciation occurred during the marriage, and there's an argument that although they may have not contributed directly financially, there are non-economic contributions, right, that they made that allowed you to provide, to continue to fund that retirement account. So they can make a claim. Retirement accounts are really messy to actually divide. So if that's the road you're going down, please, please, please make sure that you get legal advice and you find someone who can actually divide them properly. A lot of folks get tripped up and don't actually do the division part of it properly, and that can come back and be a real pain in the butt down the road. But the basic answer to the question is yes. A lot of times spouses do have a claim to the retirement accounts of the other spouse, but you will want to check with an attorney for your specific situation if you have any questions. I also get the question a lot, and we kind of covered it, is, well, what if nothing's titled together, right? Like we always kept our finances separate. I don't have anything that it has his name on it. He doesn't have anything with my name on it. Can we just take everything and run? You may very well be able to, and if that's what y'all agree to, fantastic, right? Remember, the court wants the spouses to reach an agreement, and if both of you say, let's take our own stuff, hit the road, thanks so much, see you later, and we feel that that's fair, great. That's your separation agreement right there. But why we do all of those financial disclosures is so both of the spouses know what all the numbers actually are, right? It's one thing to say you take that bank account in your name, but if you realize that there's more money in it than maybe you anticipated, you may have a different feeling about that, right? And so we want to make sure everything's laid out on the table and that you know what the other spouse has that is in their name. And that may change your feeling about things or make you feel that that's not quite a fair distribution to just take everything we have and say our goodbyes. But sometimes it is. And certainly if that's the case, if everything has been titled separately, it makes it real easy pragmatically to divide everything, right? Because you're not having to transfer titles. You're not having to go to the bank and remove one party and go through that process. Everything's already titled independently. But that doesn't mean that automatically everybody just takes what's in their name and then we're done. We still have to go through that process of laying it all on the table, understanding all the values, because most likely, even though it's only in your name, if it was acquired during the marriage, appreciated during the marriage, something happened to that account during the marriage, that's going to be marital and we have to address it. So titling alone, although makes it easy to divide logistically, doesn't get you out scot-free to just say, oh, we don't have to worry about figuring out the marital estate because we're just going to each take our own stuff. So still part of the process, and a question that I get a lot because it just seems like it should be super easy, and sometimes it is, but it's a part of the process you have to go through and check off. So as I've mentioned several times, the court wants the spouses to reach an agreement. It just makes it easier for everyone involved. You keep control over the outcome, over your money, over your finances when you can reach an agreement. And that really is the trick to getting divorces done for less than $500. There's no gimmick or catch here. If you can reach an agreement and if you can compromise, that's the secret sauce, right? Because then all you're doing is filling out the paperwork. You're going through the process. You're still going to have to go through every single step. You're still going to have to make all of those disclosures, but you're not going to spend a bunch of money fighting, paying attorneys to fight or paying attorneys to make the process more complicated because you've reached an agreement. And a lot of times what I'll tell spouses is because divorces are really emotional. And like I mentioned before, if you were wronged or you're angry or the other person was just, a jerk to you, it can be really hard not to let go of you feeling like, you really deserve something for having gone through that. But when you take a step back, what I found often is what people will be very focused on is $2,000 in a bank account. And they say, half of that is mine. I should get more than half of that because, of what happened in this marriage and you're the reason that we're getting divorced. Whatever it is, right? Those emotions are running really high. But if you're fighting over $2,000 or $1,000 or $10,000 and you're going to spend double, triple, quadruple, more than that to get that amount, is it really worth it? I understand the principle of it. I think you deserve every single penny. But do you really want to spend $20,000 to get $6,000? Right? I mean, at the end of the day, are you really setting yourself up for the next chapter to be something that you can really thrive in? I get it. I get the emotional aspect of it. But when traditional attorneys can cost somewhere of an average of $15,000 to get through a divorce, and that goes up the more that the spouses can't agree on things, even their small things, big things, whatever they are, the more you're fighting about and the more you can't agree on, that cost is only going to go up. Is it really worth it? So just keep that in mind. If it's something that you can say, you know what, maybe you believe in karma, maybe you're like, I'm just going to cut my losses, whatever it is, it might be worth it just for your well-being and mental health going forward. But if you can reach an agreement, that's going to be the trick to getting it done, because all you will pay at that point is the filing fees and those kind of costs like mediation that are going to be required no matter what. But you're certainly going to stay away from paying thousands and thousands and thousands of dollars to attorneys to get you through the process, and save yourself a little bit of money. So if you can compromise, that's the trick. You can get it done for less than $500. And if you're thinking, I really think that will work for me and my spouse, we're obviously not getting along because we're getting divorced, but we can have civil, reasonable conversations with each other. But man, this process is so freaking confusing and there's so many steps and I don't know what forms to look at, even though they're all online, and what do I do first and how do I fill this out, right? If you're in that boat and you're just looking for information and a guide that will take you step by step through the process, you can still get it done for under $500 if y'all can reach an agreement and get some additional support that you need by going to Law Guides, which is at colawguides.com. This is an online guide that I have developed doing this every day to help folks with the process, to just understand step by step what you're supposed to do. Here's step one. Here's the form you need. Got that done. Great. Go on to the next step. Here's the form you need. It helps you keep it organized. You can go at your own pace. You get all the forms that you need. I even include that spreadsheet that I was talking about earlier as a template so that you can put all your assets and debts in there and know that you're covering everything. That is all included for less than $25 a month. So you can use it as long as you need it, and you can get all of the information and all of the forms that you need from start to finish and still get your divorce done for less than $500, even with the addition of using Law Guides. And again, that's colawguides.com. If you are interested, colawguides.com. You can sign up today. Again, less than $25 a month. If you're thinking, that sounds amazing, but I think I'm going to need to talk to someone because Lauren said a bunch of times that this might be your situation, and I'm going, yeah, that's my situation. I also offer several other services, including monthly coaching to get all of those questions answered, to talk to you about your specific situation. You still save a ton on cost because you're doing a lot of the legwork yourself, but you're getting that additional legal help and advice that you might need for your particular situation. Like, what do I do with my retirement account? Here's my situation. You can get that information direct from an attorney to be able to help you. If you're thinking you need more than that, please check out my website. It's mylifelawyer.com. I have a number of flat fee packages depending on the level of involvement that you would like from me as an attorney. You can see all of the cost, all of the services that are involved. That way you have a range of options. You don't have to go into debt. You don't have to flush out your savings. You don't have to drain your retirement account to get divorced. It is my hope that I can help people not do that, but still be able to go through the process in a way that you feel empowered, you have all the information you need, you make the best decisions for yourself, and you get done with it, right? No one wants to sit in this storm unnecessarily for too long. So if you need some of that higher level of help or more involvement from an attorney, you do have some options that aren't the traditional billable hour where they ask for a several $1,000 retainer and you don't honestly know what the total cost is going to be. But if you look at the average and you're looking at $15,000, $20,000, that may not be in your budget or what you want to spend. So there are other alternatives out there. You just got to look for them. So a great starting place, mylifelawyer.com. Check it out. You can also schedule a free consultation right from the website. That is all that I have for you today. I know that we went over a ton. We covered how the court will generally look at to divide the marital estate, the property and debts between the spouses, what they're going to look at, how you can avoid having the court make decisions about your money, how you can get divorced for less than $500, and what those steps are. So I will be back next month. We will dive further into the process. We'll bring back in, like I said, some of those custody cases that aren't dividing assets but still have financial decisions that need to be made. And I will be here every second Wednesday at 12 p.m. at Mountain Standard Time, answering your questions and providing the information to make the legal process just a little bit easier and less confusing. Thank you so much for joining me today. I wish you a great day, and I'll see you later. Bye-bye.